Hello and welcome to Workers Comp Unwrapped, the podcast that simplifies workers' compensation for physicians. I'm your host, Max, here to give you clear, actionable insights to navigate the medical legal side of workers' comp. So let's get started. Welcome to Season 2, Episode 21 of Workers Comp Unwrapped with Max and Aisha.
Great to be here.
Aisha has 15 years of experience in the workers' comp industry. Today we are talking about understanding workers' comp subrogation, what providers should know. Now, if you're a doctor, a provider dealing with work injuries, you definitely know the feeling. Payments can be incredibly slow.
Oh, yeah.
And navigating the whole workers' comp system, it feels like a constant uphill battle.
It really can.
So today we're diving into one of the big reasons for that frustration. Subrogation. It's, often why your perfectly clean bills just sit there unpaid. All because the insurance company thinks maybe, just maybe, someone else should be footing the bill.
Exactly. Passing the buck, essentially.
Right. So our goal today is pretty simple. We want to arm you, the provider, with the actual facts about subrogation. We'll break down what it is, point out some common traps, and crucially explain how you can protect yourself and your practice. And you spend years in the trenches with these subro battles, right?
Yeah, quite a few. Seen a lot of it.
Okay. Let's jump right in then. Subrogation. What exactly are we talking about here? Lay it out for us.
Okay, so basically subrogation in workers' comp. It's the legal right an insurance company has. It lets them step into the injured worker's shoes, legally speaking.
Step into their shoes. How so?
Well, if your patient's injury wasn't just, a simple workplace accident, but was actually caused by someone else, a third party.
Like not the employer.
Right, exactly. Someone else entirely. Think negligence. So the workers' comp insurer pays the initial medical bills, lost wages, things like that. But then, because this third party was at fault, the insurer gets the right to go after that party to recover the money they paid out.
Okay, so they pay the bills first, but then they try to get reimbursed from whoever actually caused the injury.
That's the core idea, yeah.
Can you give us a really concrete example? Make it real.
Sure. Let's say you're treating a patient, maybe physical therapy. They're a delivery driver, and they got injured in a car crash while working, but the crash wasn't their fault. Someone else ran a red light and hit them. Clear fault.
Got it.
So the workers' comp insurer starts paying for the PT, maybe temporary disability, but because that other driver was negligent, the workers' comp insurer now has this subrogation right. They can legally pursue the at-fault driver's auto insurance to get back every dollar they spent on the claim.
Right, makes sense for the insurer. They want their money back. But for the doctor, the PT clinic in your example, what's the immediate impact? What's the pain point?
The biggest one. The one that causes just endless frustration, payment delays. Big time. While the insurer is busy investigating who's liable, arguing with the other driver's insurance, maybe dealing with lawyers, your legitimate bill, they can just stall unpaid.
Even though you provided the care.
Exactly.
Yeah.
You did your job, submitted a clean bill, but your payment gets tangled up in this whole separate legal fight about who ultimately pays.
So it feels like you're sort of held hostage while they fight it out. They have this right to subrogate. Does that mean we as providers just have to wait indefinitely, or are we just stuck?
No. Absolutely not. And this is super critical for providers to understand. This is key fact number one, really.
Okay.
California Labor Code. Sections 3850 through 3865.
Right.
Yes, they grant insurers the right to subrogate. No question. They can go after that third party. Huge but. Those same laws do not give them a free pass to ignore their duty to pay you on time, according to the normal billing rules.
Okay. So their subrogation effort is separate from their obligation to pay my bill.
Totally separate. That's the distinction that gets missed so often. They can't just say, oh, subro, and stop paying you promptly.
Let's really nail this down, because I think the common thinking is subrogation case. Okay, payment's going to be months, maybe never. Is that legally wrong?
Completely wrong. That idea of an automatic, indefinite delay just because subrogation might be involved, it has no basis in law. And here's your proof, your weapon. Labor Code Section 4603.2.
Okay. 4603.2. What does that one say? What teeth does it have?
It's very clear. It says claims administrators, the insurers, the third-party administrators, they must process and pay clean electronic medical bills within 45 days.
45 days. Flat.
45 days from when they receive it. Now, okay, if you happen to have a PPO contract with them, that might stretch it to 60 days.
60, okay.
But the fundamental point is there is a legal deadline. And it applies whether they're chasing some third party or not. Their subrogation fight is their business. Paying your clean bill on time is their legal obligation.
Wow. Okay, the law says pay within 45 or 60 days. So why? Why does it feel like these delays are everywhere? You hear it all the time. Pending subro. Are they just using it as an excuse?
Well, it certainly feels that way sometimes, doesn't it? And countless providers will tell you they hear exactly that. We're waiting on the third-party stuff before we pay you. But under California law generally, that is not a valid reason to hold up your payment past that deadline in 4603.2.
Remember that number, folks, 4603.2. This changes things. It means providers can't just be passive. You can't just submit the bill and cross your fingers if you hear subrogation.
Exactly right. You have to be proactive. Don't just send it and forget it, especially if the way the injury happened even hints at someone else being involved.
Like our car accident example.
Perfect example. Follow up, check the status, ask direct questions. But honestly, even more powerful than just chasing the payment. There's another crucial legal tool providers need to know about.
Okay, I'm listening. What's the second key takeaway?
Okay, key fact number 2. California law gives you, the medical provider, a really important protection. It's the right to file a lien, but specifically a lien in the third-party civil case.
Whoa, hold on. So not just the usual lien we file in the workers' comp system, a totally separate lien. Filed where? Like in regular court?
That's exactly right. It's under Labor Code Section 3856. It's a different animal entirely. This lien basically attaches your claim for payment directly to any money, a settlement, or court judgment that the injured worker gets from the person or company that caused the injury.
Okay, back to our delivery driver hit by the red light runner.
Yes. So, if that injured driver sues the person who ran the red light, your clinic, the doctor, the physical therapist, you can file your own lien directly in that car accident lawsuit.
And what does filing that lien actually do for me?
It officially puts your claim on record in that case. It basically tells the court, the worker's attorney, the defense attorney, hey, when this lawsuit settles or goes to judgment, part of that money is legally owed to me for the medical care I provided for this specific injury.
So it puts you directly in line to get paid from that specific pot of money.
Exactly. You're not just relying on the workers' comp insurer anymore to maybe, hopefully, remember your outstanding bill when they get their subrogation money back.
You're taking direct action.
You are, to secure your payment directly from the third-party funds.
Okay, what happens if a provider knows there's a lawsuit or strongly suspects one, but they just don't file this separate civil lien? What's the risk?
Oh, it's a huge risk. Massive. That third-party case could settle. The money gets paid out to the worker, to their lawyer, maybe the comp insurer gets their share back. And you could be completely left out, overlooked, your bill's still unpaid. Then you're stuck trying to chase the insurer or maybe even the patient long after all the settlement money is gone. It's a really bad spot to be in financially.
Wow. Okay, so we know what subro is. We know the payment delay excuse is bogus under 4603.2. And we know about this powerful civil lien under 3856. Where do providers usually mess this up? What are the common pitfalls?
Well, one of the biggest mistakes, and honestly one of the costliest, is simply not recognizing that a case even has subrogation potential right from the beginning.
They just see work injury, treat it, bill it, and they miss the clues.
Exactly. They handle it like any standard workers' comp claim, and they completely overlook the signs that a third party might actually be responsible.
So we need to be better detectives. What are those red flags? What should providers be looking for?
Okay, definitely pay attention to how the injury happened. Was it a car accident? Any kind of motor vehicle incident? That's a huge one.
Got it. MVA equals potential subro. What else?
Did the patient mention anything about problems with equipment, tools, machinery?
Especially if it wasn't the employer's own equipment, right? Like faulty scaffolding from another contractor or a defective machine brought onto the site.
Perfect examples. Or maybe a slip and fall, but it didn't happen on the employer's property. Maybe it happened at a client's location due to some hazard they didn't fix.
Right, like a premises liability situation.
Precisely. And here's a really big one. Did the patient mention, maybe early on, that they've talked to or hired a personal injury lawyer?
That's like a flashing neon sign, isn't it?
Absolutely. It means they are definitely thinking about legal action beyond just their workers' comp claim.
Okay. Any other clues? Maybe from the adjuster.
Yes. Listen carefully to the language the workers' comp adjuster uses. If you start hearing phrases like third-party involvement, potential civil action, possible recovery, or outside settlement.
Those are dead giveaways they're looking at subrogation.
Bingo. Those terms should immediately make you think, okay, wait. Is there a third-party case here? Do I need to think about filing a lien?
So pitfall, #1. missing the signs entirely. What's another common way providers trip up?
The second big one is kind of the flip side. It's knowing or having a pretty good idea that there is a third-party lawsuit going on, but then failing to file your own provider lien in that civil case.
Okay, why would that happen? If you know there's a lawsuit, why wouldn't you file the lien?
Often it just comes down to assumptions. You might think, well, the workers' comp insurance company is handling the subrogation, right? They're involved. They'll make sure I get paid out of the settlement.
That sounds dangerous.
It's incredibly risky. You have to remember the insurer's main goal in that civil case is to get their money back, their payouts. They aren't necessarily focused on making sure every single one of your outstanding medical bills gets paid in full from that specific pot of money.
Right. Their priority is their own bottom line.
Yeah.
They might not even know the full amount you're still owed, or your specific bills could just get lost in the shuffle during settlement talks.
Exactly. You absolutely need your own independent lawyer to stake your claim and protect your financial interest in that separate lawsuit.
Man, this really highlights how providers need to be almost legally aware these days. It's not just about the medicine.
Unfortunately, yeah, that's the reality of workers' comp. Understanding these legal tools like the civil lien is becoming really essential just to keep the practice financially healthy.
No kidding. Okay, let's switch gears slightly. Let's tackle some specific common questions providers have about this whole subrogation mess. Maybe like a rapid-fire Q&A. You ready?
Yeah, let's do it. Hit me.
Okay. Question 1. Can the workers' comp insurer legally delay paying my clean, undisputed bill just because they say they're pursuing subrogation? Simple yes or no.
No. Absolutely, unequivocally no.
Because of Labor Code 4603.2, right? Those payment deadlines are law. Supro doesn't pause that clock. So what should a provider actually do when they get that excuse?
Push back. Immediately and firmly. File a second bill review appeal, and in that appeal, specifically state that pending subrogation is not a valid reason for delay under LC 4603.2 if they still refuse. Demand independent bill review, IBR, don't let them get away with it.
So the message is basically, I hear you on the subro, but the law says you owe me now, pay the bill.
That's it. Cite the law, be persistent.
Okay, question 2. Do I really need to file that civil line every single time there's even a possibility of subrogation? Seems like a lot of paperwork.
That's a fair question. Look, if a third-party civil lawsuit has actually been filed, or you have really strong evidence that one is about to be filed, then yes, absolutely file that lien. It is, hands down, the most secure way to make sure you get paid from any money recovered in that case.
Even if workers' comp is paying some of the bills currently?
Yes, because the civil lien protects your claim against that separate settlement or judgment money from the third party. It ensures you get your piece of that pie before it gets distributed elsewhere.
Right. Without it, you're just hoping someone remembers you when the third-party check comes in.
Risky.
Very risky.
Question 3. How can I be sure if a case has subrogation potential? Let's quickly recap those warning signs again.
Okay, top signs. Any kind of car accident or motor vehicle involvement, that's a big one. Injuries caused by equipment or machinery that the employer doesn't own.
Right.
Injuries that happen off the employer's property, like a slip and fall elsewhere, a big one.
Yeah.
The patient mentions hiring or talking to a personal injury lawyer.
Okay.
And listen to the adjuster terms like third party, civil action, potential recovery, outside settlement. Basically, if the injury story seems complicated and involves more than just the employee and their direct employer, start thinking subrogation.
Good rule. Complexity often equals subrogation potential.
Often, yes.
Right.
Okay, question 4. Uh-oh. What happens if I realize too late? What if I missed the deadline to file my lien in that third-party civil lawsuit? Am I just sunk?
That's a tough spot. Unfortunately, if you miss the deadline for filing the lien in the civil case, which is usually before it finally settles or goes to judgment, you likely lose your legal right to make a direct claim on those funds.
So that potential source of payment just poof, gone.
Pretty much, yeah. Your secured claim on that specific money disappears. Your options for getting paid become much, much harder after that.
Ouch. So procrastination here can literally cost you the entire bill amount.
It absolutely can. Financially devastating sometimes. You're left chasing payment through other, much less certain avenues.
Okay, question 5. Can I just skip workers' comp? If I know a third party is clearly at fault, like that red light runner, can I just send my bill straight to their auto insurance? Get out the middleman.
Generally, no. That's not how the system is set up for work injuries here in California. Workers' compensation is considered the primary payer. You're typically required by law and regulation to bill the workers' comp carrier first.
Even if it seems obvious, someone else should pay.
Even then, The system requires you go through workers' comp initially, that civil lien we keep talking about. That's your tool to eventually get money from the third-party settlement after you've billed workers' comp. Trying to bypass WC usually just causes more problems.
Right, it can mess things up administratively, maybe even violate rules. Stick to the process, bill WC, then file the civil lien.
That's the standard, safest approach.
Got it. Last question in this round, question 6. What if the main workers' comp case settles? Let's say it ends with a compromise and release, a CNR. But my bill wasn't fully paid, or maybe it wasn't even included in that WC settlement. Am I out of luck then?
Not necessarily. This is where being proactive really pays off. If you properly filed your lien in the separate third-party civil case before that workers' comp CNR happened, then your lien and your right to get paid from the third-party settlement usually still exists.
So settling the workers' comp case doesn't automatically kill your lien in the separate civil case.
Correct. Your civil lien is attached to the potential money in the civil lawsuit against the third party. So even if the WC case is closed, if that third party lawsuit is still going or eventually settles, your lien gives you a legal path to get paid from those funds.
But only if you file that civil lien beforehand.
Exactly. If you didn't file the civil lien, then yes, once the WC case settles via CNR, especially if the settlement paperwork has language releasing all liens against WC benefits, your chances of recovering that unpaid amount become very, very slim. It's yet another critical reason why filing that civil lien is so vital.
It really is the key safety net, isn't it?
It truly is in these complex cases.
Okay, this has been incredibly helpful in understanding the provider's perspective and rights. Thank you so much for breaking all that down.
You're very welcome. It is complicated, no doubt, but hopefully, understanding these rights, the payment rules, and especially that civil way, it empowers providers to actually take control and not just feel helpless.
Absolutely. So, boiling it all down, the golden rule for providers listening seems to be stay relentlessly proactive whenever subrogation is even mentioned. Assume nothing.
Couldn't have said it better. Spot those red flags early. File those civil liens promptly and correctly. Don't ever assume the insurance company or someone else is going to protect your interests.
And hammer them on those payment deadlines.
Right.
Remember, 46603.2, 45 or 60 days. Don't let them use pending subro as an illegal excuse to delay payment.
Exactly. And look, if managing all this, the liens, the follow-up, arguing with adjusters, if it feels like too much on top of patient care, don't be afraid to seek expert help.
Yeah.
There are firms that specialize in navigating exactly these kinds of workers' comp billing complexities.
Because the real bottom line here is, even if a third party was responsible for the injury, that should never be a reason why your practice ends up writing off bills months or years later.
Well said. You need to protect your practice's financial health.
Thanks again for sharing your expertise, and thanks everyone for tuning in to Workers Comp Unwrapped. We really appreciate you joining us.
My pleasure.
Until next time, here's something important to think about. Don't let those cases marked pending subrogation just languish in your accounts receivable until they become write-offs. You have rights. You have tools, especially that crucial civil lien. Use them to fight for the payment you earned for the vital care you provide. Thank you for listening to Workers Comp Unwrapped. If you found value in today's episode, share it with your fellow medical providers and healthcare specialists. For more information, contact us at lena.klein@medicallienmgt.com or visit our website, medicallienmgt.com.